They're going to have to take down the Ten Commandments in Kentucky schools. 2 years ago, a law was passed requiring the Ten Commandments be posted in every public classroom so long as printing costs were paid privately. But today, the Supreme Court struck down the law without even hearing argument.
In 1978, Kentucky passed a law requiring the Ten Commandments to be displayed in public classrooms. The state mandated that printing costs be paid privately, but it wasn't enough to stop the law from being overturned by the Supreme Court 2 years later in an unsigned 5-4 ruling. Stone versus Graham held that Kentucky's law was unconstitutional, that it violated the First Amendment's Establishment Clause, which requires the separation of church and state. The ruling set a powerful precedent, one that several other states have since tried to break. States like Mississippi, Oklahoma, South Carolina, Utah, and Texas have all tried to pass similar laws in recent years, but none have been successful. Cut to this week, when Louisiana Republican Governor Jeff Landry took a shot. On Wednesday, Landry signed a new law requiring all public classrooms to display the Ten Commandments. Even before signing the bill, the governor anticipated legal challenges, told a room full of Republican donors, quote, "I can't wait to be sued." And his wish, well, it will soon come true. The ACLU, along with Americans United for the Separation of Church and State and the Freedom from Religion Foundation, have announced they will sue Louisiana over the, quote, blatantly unconstitutional new law. In a joint statement, the organizations wrote HB 71 would require school officials to promote specific religious beliefs to which people of many faiths and those of no faith do not subscribe. The government of Louisiana should not be coercing students to submit day in and day out to unavoidable promotions of religious doctrine. First glance, it might seem like this is a slam dunk case for the ACLU. Even if the case makes it all the way to the Supreme Court, the precedent set by Stone versus Graham should ostensibly mean that Louisiana's new law is overturned, right? Well, not so fast. This is a highly politicized Supreme Court, a court that has recently made decisions that expand the place of religion in public life, suggesting that if this case ever makes it to the highest court, there might be a majority willing to uphold Louisiana's new law. Just 2 years ago, in a 6-3 vote, the Supreme Court sided with a high school football coach in Washington, ruling that the coach had a constitutional right to pray at the 50-yard line after games, even if some players felt pressure to join him. Writing for the majority, Justice Gorsuch claimed, "Respect for religious expressions is indispensable to life in a free and diverse republic." And just last year, the court's conservative majority ruled 6-3 in favor of an evangelical Christian artist who didn't want to design wedding websites for gay couples. Given those rulings, if Governor Landry hopes that the ACLU lawsuit against him will reach the Supreme Court, it seems more likely than ever that this court might uphold his Ten Commandments law.
This bill mandates the display of the Ten Commandments in every classroom in public, elementary, secondary, and post-education schools in the state of Louisiana. Because if you want to respect the rule of law, you got to start from the original lawgiver, which was Moses.
That was Louisiana's Republican Governor Jeff Landry yesterday, giving a shout out to Moses after signing Louisiana's Ten Commandments bill. Now, you may have noticed a small girl behind him appeared to faint during the event. I hope she's okay. But Louisiana's new law means that starting in 2025, every public classroom in the states will have to display those Christian verses on a poster no smaller than 11 by 14 inches in a large, easily readable font. Joining me now, Alana Odoms, Executive Director of the ACLU of Louisiana. Also joining us, Anthea Butler, MSNBC columnist and Chair of Religious Studies at the University of Pennsylvania. Two of the smartest women that I know. Thank you both so much for being here tonight. Alana, what's the impact of this law?
HB 71 being signed into law means that children all over the state of Louisiana in every single classroom, whether it be their math classroom, their art classroom, will be subjected essentially to codified Christianity. Our schools, our public schools, are going to be turned into Sunday schools. And throughout the time that we have been studying this law, we know one thing, that the First Amendment and its free exercise clause, which allows each and every United States citizen to choose their own faith or no faith at all, and the importance of the Establishment Clause, which says that the government should not interfere, coerce, proselytize, or choose or give one particular religion preference over another. Those two clauses are still incredibly important in the United States Constitution and for the First Amendment. And so we believe in challenging this law, we will ensure that freedom of religion and the First Amendment are still rights that Louisiana citizens hold.
And it would be really easy to look at this story and say, well, it's just happening in Louisiana, or that's just Governor Landry. No, you have been very clear. This is part of a well-funded, well-constructed movement. Pull back the curtain for us. Who and what is behind that movement?
Many things, Alicia, but one of the things I think is really important for people to say is that, A, this is an old playbook, and there have been lots of organizations over the years that have done this, whether we're thinking about Heritage Foundation, Family Research Council, all of these kind of Christian groups, alongside of other groups that have been working in school boards and other places to do this. What I think is really important for people to understand is two things. One is that we keep having the same repeat over and over again. We want prayer back in schools. We want the Ten Commandments in schools. We want to post up religious figures in schools. And what gets me about the Louisiana law is that there are over 1 million Catholics. This is a Protestant version of the Ten Commandments that they want to put up. And this is the crazy part. There are actually 3 different versions: a Jewish version, a Christian version, a Catholic version, and a Protestant version. And are we going to be able to put up all 3 kinds of Ten Commandments, to say least about even putting them up in the first place, which I think is wrong.
You know, you take sort of the context that we built this up in, which is the idea, Anthea, that this could be headed to the Supreme Court. We recently heard Justice Alito in a recording agreeing that the country needs to be returned to, quote, a place of godliness. Just last month, we saw reporting about the appeal to heaven flag flying at his vacation home. If you think about this as a pipeline to the Supreme Court, how much does that alarm you?
It alarms me greatly, because I believe that this Supreme Court might go ahead and say that this is okay to do. Obviously, the 2005 ruling by the Supreme Court that said Kentucky couldn't do that was a different Supreme Court than what we have now. And this is the thing that we have been talking about over and over again, this kind of Christian nationalism that will put other kind of morals on top of everybody else who don't even practice Christianity. What about Muslims? What about Jews? What about atheists? What about everyone else who doesn't believe that the Ten Commandments are part of their belief system? I think it's disingenuous for Louisiana to do this in the guise of creating more morals, when obviously the Christians that are running things sometimes think about that they don't even follow these rules themselves. And that's what I think is the hypocritical part of all of this.
Well, not only do they not follow them themselves, they are lining up behind a person who sort of astonishingly does not follow any of them. We'll get to that in a second. Alana, the Supreme Court, they have a precedent known as the Lemon Test, established 1971, Supreme Court case called Lemon versus Kurtzman. It has been used in many First Amendment cases. Explain what it is, whether it could be challenged.
Yeah, absolutely. So in Stone versus Graham, the court articulated a 3-part test. The Lemon test first says that you have to look at the purpose or the intent of the piece of legislation. Does it have a secular or a non-secular purpose? And in the Stone case, the court did not have to go to the second and third prong, because it was very clear that requiring a religious scriptural document like the Ten Commandments was clearly a religious intent, and therefore they did not have to go further, and they struck it down based on that. Parts 2 and 3 of the test, Part 2 is essentially an effects test. It's looking to determine whether or not the effect of the law will cause the government to prejudice one religion over another, or to preference one religion over another. And then you're looking at entanglement. Does the government have unnecessary entanglement into religious affairs? And we know that the strong principles of the Establishment Clause really require that the government remain neutral and not choose a particular stance. And so the reason why we're in a bit of a tenuous position is that the court set aside the Lemon test in 2022 in the Kennedy case. But what we will say is that there is no federal court that has ever declared that holding the Ten Commandments and posting them in the classroom is constitutional. That has never been done. And also the 2022 Kennedy case is distinguishable from these particular facts because the court, that was a very narrow ruling in 2022, where the court said that children were not required to take part in the prayer. This was really something that the coach was doing on his own, and the kids were not a captive audience. Here in Louisiana, where K through 12 education is mandated by the state, our children are a captive audience. They are particularly a vulnerable group, and having this religious scripture in every classroom is indoctrination, and it does strike at the heart of our religious freedom of exercise of religion and also the Establishment Clause.
Well, and Anthea, especially when these are some of the same people going on and on about parental rights and worried about which books are on your kid's bookshelf at school. Meanwhile, they want to foist their religious beliefs onto children and, by extension, their parents. So none of this is actually to them about freedom. It's not about godliness. It's the same people lining up behind Donald Trump. If it is not about any of that, then what is it actually about?
It's about using morality as a way to get power. It is a way to have power and authority in the schools. It is a way to dictate what people learn, obviously, with all the book bans and everything that's been going on. It's a way to instantiate Christianity as the religion of the land. And that is not the case. Obviously, you've heard about the Establishment Clause. There will be no religious tests for president. But these are all religious tests. And there are ways in which they are using the public school system to do this at the same time asking for vouchers, asking for accommodations for private schools that they will send their children to. So this is not simply about how you put religion and making morality, as he says, to make kids better. It's about them instantiating their Christianity as A, the law of the land, and B, as the religion that everyone should follow, whether or not they follow those tenets themselves.
Anthea Butler, Alana Odoms, thank you both so much for being with us.